Will the April 27, 2015 Legislative Committee meeting of the Contractors State License Board come to order? I'm Joan Hancock, Committee Chair. I'd just like to pause for a moment in remembrance of the folks that died in Nepal from the earthquake, and there was over 3,200 people that perished. And in addition to that, there's a lot of homeless people, people that have no food, no clothing. Our governor sent from OES a rescue squad, safety and rescue squad of 57 people, so maybe we can remember them in our thoughts and just take a minute of silence. All right. And then we'll proceed. Only board members who are members of the committee may sit at the table. Other board members who are in attendance must observe from the audience. If a quorum of the board is present, those members who are observing cannot participate in the discussion. Laura, will you call the roll, please?
Joan Hancock?
Here.
Augie Beltran?
Here.
Linda Clifford?
Here.
Paul Schifino?
Here.
Nancy Springer?
Here.
We'll now do committee meeting and staff introductions, and also people in the audience. If you'd like to introduce yourself, it's not it's completely voluntary. So would you start, Karen? Augie.
CINDI Christenson, Registrar.
Laura ZUNIGA, Chief of Legislation.
Joan Hancock, board member.
Linda Clifford, board member.
Paul Schifino, board member.
Christy Shilge, counsel for the board.
David Fote, Chief of Enforcement.
All right, thank you. Agenda item B, public comment. This item is provided for public comment pertaining to items on the agenda as well as items not on the agenda. However, the committee cannot take any action on items not listed on the agenda. The CSLB welcomes public comment and Bob Lamb on any item on the agenda, and it is the CSLB's intent to ask for public comment prior to the committee taking action on any agenda item. But if for some reason we forget to ask for public comment on an agenda item, a member of the public desiring to comment on the item should raise their hand and be recognized. Also, we will be limiting public comment to 5 minutes per person per individual. Are there any individuals that wish to address the committee at this time? All right. There are none. Are there any committee members that have any other comments prior to proceeding to agenda item C? Agenda item C, review and discussion of possible action of recommended position on the following bills. We have a number of them, several of which are not going to require a motion. Staff will be recommending a watch position. We'll just take them real quickly one by one. The first one is AB 500. Assemblyperson Waldron. There's no motion needed on this. This is really to make the committee aware of the bill, and this bill is intended to enhance employment opportunities for the previously incarcerated or substance abuse rehab graduates. It provides that A private employer, including a nonprofit entity, may deem a person an independent contractor for a period of no more than 2 years from the successful completion of a substance abuse rehab program. If the person was convicted of a felony or misdemeanor for substance abuse, it excludes violent felonies. It provides that it does not prohibit a private employer for employing such a person as an employee rather than as an independent contractor. And it further provides that it does not prohibit a person from obtaining union membership during the term of the rehabilitation program. In looking up this bill, I noticed that the subsection A, the very first sentence that comes out of that says, notwithstanding any other law. So that's what we will be dealing with because we have other laws that we are aware of and will have to be taken into consideration. Any questions about that or comments? Yes, Paul?
I had one question, Joan. I read through this, and the summaries are great. We need them, Laura. I need the summaries, and that's wonderful. But I was so confused after I read this and what's going on that we're redefining what an independent contractor. An independent contractor for no more than 2 years. An independent contractor can be an independent contractor forever. What's this redefining of what an independent contractor is?
So this bill is a little unusual. We wouldn't normally consider something like this, but as Joan mentioned, because of the way the language of the bill is worded, it's going to override our law. So what the author is trying to deal with is people who come out of substance abuse programs and provide them a narrow, I guess, tailoring of the law for independent contractors to allow more of those people to be classified as independent contractors, presumably so more employers would be willing to hire them if they're not willing to take on the liability of hiring them as a regular employee. So that would override the provisions of our law that allow employees to work under a licensee's exemption and not require a license.
So just to make it clear, I hate this idea because it's confusing. It's going to confuse the contractors of the world as to who's what, where, and when.
Right.
So it's not our fault. We're not the ones, we're not promoting this, but I think it's a terrible way to approach. Maybe it's a real problem, but a bad approach to resolve it.
Right. The bill hasn't been heard in committee yet. It's going to be up, I think, in 2 weeks. I'm not confident it will make it out of committee, so I think if it does advance further in the process, we'll bring it back to the board to vote on. We did suggest to the author's office that they just exempt out our licensees because I think it would have the effect of making it harder for people to get licensed as contractors rather than making it easier for people to work as an independent contractor in construction. So they're looking into that.
Okay, and the only other thing that I wanted to mention was, and you could shut this down and you guys chime in and tell me if you think I'm crazy, the legislation itself, is it like just a one-page deal, and then this is a summary of a one-page deal? And what I'm alluding to is, does it make sense to attach the actual legislation to the summaries so that we see it?
Yeah, that's a good question because we've never done that previously. This is a pretty short one, but it may make sense, I think, in this particular one because it was confusing as to how it interacts with our law. So I can do that in the future, and then we can see how the committee and the board like it and if it's worthwhile.
I like the idea, and then we can
Okay.
always dump it if it's a bad
Right.
idea. If something comes along that's 50 pages long, don't bother. I don't.
Yeah, and they
want
do
it.
have, it's available now where you can print out, as bills are amended, it will continually update the text of the bill so you can see what's amended from existing law and what's changed with each version of amendment. So it'll be easier for the committee member and the board members to track it.
FYI, I did not have any previous or other information from Laura. I just Googled it, and I go to the top of the Google list, to be, assuming it's the most current, but certainly our chief of legislation, Laura ZUNIGA, knows what's most current because she follows these bills. So, Christy.
I'm new to this board, but every other board I've ever worked with for 15 years puts the legislation in the packet because they want to make sure that their members are voting on something that they have read. And that could be a problem for you down the road if somebody is voting on something they have not read. That could be subjected to legal challenge or reversal on things, And you could certainly run into problems with an author if your board members are voting on something that they have not read. So I don't know what your training is. Maybe your training to your board members is to look it up on the web, but just, out of an abundance of caution, I would encourage you to include the legislation with your packets so that you don't have people challenging whether you're making an informed decision on a position because you have only read the summary and not the actual text of the legislation.
Yeah, and this is probably something we should ask or maybe put on the agenda for the full board. So, I mean, it involves everyone.
I think we'll just include it from here on out, and more information is not a bad thing for members.
Okay, great. Anybody else? Members of the public, any comments? Yes, Christy.
I just want to make sure that the members understand the effect if we are unable to get an exemption. What that would mean is that people that normally would be able to get exemptions under 7053 of the Business and Professions Code, because they would be under the umbrella of the contractor, the general contractor that they're working for. This bill would take them out of that exemption, meaning those personnel that normally wouldn't have to get a license individually with the board in order to lawfully work would have to get a contractor's license, would have to get background fingerprinted, would have to go through that entire process when they normally would not, because they're personnel working for as an employee of a contractor. So just so you understand the effect and why we suggested the exemption to your law, because I think it would cause significant changes in the way you administer your act.
Anyone else? Paul?
I might as well finish it. I think at the end of the day, I'm looking at it going, I don't want to watch it. I want it to go away.
I think if it makes it out of its first policy committee hearing in the next few weeks, then I'll bring it back to the full board and then would recommend a position for the board. I just think at this time, where we are in the process, it's not necessary.
All right, so we're not taking any action. We're just going to watch it, and we're going to move on, if you will, to AB.
Joan, I'm
yeah.
sorry.
Linda Clifford.
Yeah, Linda Clifford, board member. I'm kind of on this side on this one too. I mean, I'm a little bit, is it your opinion that it isn't going to make it out of policy committee, so we don't even have to like make a statement or send a letter or do anything that would do this? Because this would be a major hardship on contractors who are trying to hire people who can't hire these people or decide not to hire these people, and then now they don't get jobs, and it feels like a round robin of
Right.
I can't get out of this hole I've dug myself into, right?
Right. It's always hard to predict the legislative process. I think it's unlikely to make it out of policy committee, so that's why I was not suggesting that the committee take a position at this time. It does have a significant impact on our licensees, as we've briefly discussed. Certainly not, I don't think, what the author intends, so we made them aware of the situation so they could consider whether or not to exempt out contractors. But I think, I don't think the board needs to weigh in before the policy committee meeting.
So they're aware of where we're at. I mean, they know, the Waldron and his staff know where CSLB sits on this right now.
Yes, I did communicate to the staffer that the impact the bill would have on our licensees and the potential that it's not going to do or have the impact they want in regards to construction, so they are aware of that issue.
Anyone else? Okay, AB 507, Assemblyperson Olson. So this bill would require the Department of Consumer Affairs to annually submit a report to the legislature and the Department of Finance that contains all of the following. By the way, staff is recommending a watch position on this as well. So number one, DCA's plan, including a timeline for implementing BREEZE for Phase 3 boards. 2, the total estimated costs for Phase 3 implementation and the results of any cost-benefit analysis that DCA conducted for Phase 3 implementation. Number 3, a description of whether or not and to what extent BREEZE will achieve any operational efficiencies. So, Laura, why don't you give a short summary of that summary?
Sure. I think all the committee members are familiar with the BREEZE system. CSLB was scheduled to be in Phase 3 of BREEZE, so we were one of the boards that would be included in this plan the department would need to provide to the legislature. Assemblymember Olson, the author of the bill, is the one that requested the Bureau of State Audit's review of the BREEZE system, and she has an interest in identifying problems with state IT projects and seeing if there are any common similarities that lead to the problems and whether there are statutory changes that can be made. So this is her follow-up to that. I think the department right now is going to complete phase 2 of the implementation of Breeze, and then they will look into doing a cost-benefit analysis for the phase 3 boards and determine what would be appropriate at that point. So I think it's just helpful for the board to be aware of this bill since we're one of the phase 3 entities. So this would include whatever is going to happen with CSLB as well as the other entities. But I don't think the board needs to weigh in on the bill. I just thought it would be good for them to be aware of the legislation.
So in following the suggestion of our council, this bill is a result of the state auditor's recommendations and assessments, and if, in following the recommendation of our council, that we have a short summary of the bill, that it would be good to have the history of where that bill originated from, which was the response of the state auditor, and which brings me to my next question, which is this consistent with the state auditor's recommendations? Is it more harsh?
I think it's consistent. I don't think it's more harsh. It's just she's looking for the report, and that was one of the recommendations of the auditor, was that there would be additional reporting to the legislature.
Comments, committee members? Any comments from the public? Okay, well, the recommendation is that we just maintain a watch position, and we do not need a motion at this time. So next is Assembly Bill 750, Assemblyperson Lowe. This has been amended. It's one of your handouts today. Just got, if you want to take a minute just to look through your handout. I'll read just the pertinent part at the bottom of the first page, and I think it continues on the back. Basically, it says, the board shall deny an applicant's application to place a license in a retired status if the license is subject to an outstanding order of the board, if suspended, revoked, or otherwise punitively restricted by the board, or is subject to disciplinary action under this chapter. So what we're trying to do, or the suggestion, is to establish a retired license category in addition to our inactive and active license. So there would be different requirements to follow, and Laura's going to explain this.
Sure. This bill was presented at the board meeting in March, and since then it's just been amended to provide further detail about how the retired licensee would be treated and how you could reactivate the license. Legal counsel suggested an amendment to the bill to allow the board to deny an application to place a license in retired status if the licensee is subject to disciplinary action. So that is at the bottom of the first page of the analysis, so we could recommend that to the author's office if the committee approves the language. And again, I just want to emphasize that this just provides the board the authority to adopt the category. We would not be required to, and then we would implement regulations if we wanted to.
Linda, Clifford.
I totally support the amendment. The amendment makes total sense, and we should absolutely have it in there. My curiosity is we're not supporting this. I mean, it's about us.
Well, it impacts all the boards within the department. So if the
Okay.
board hasn't really discussed whether or not we want to implement this category, so we certainly could support it. It's just
Right. I'm not saying we should implement it. I'm just saying it. Do we want to support the bill so we have the right to implement it if we think it's important?
We were going to ask for a motion to approve the amendments to the bill. Is that what you're talking about? The amendments that are suggested today that's at the bottom of page 1?
I totally support that. I'm happy to make that motion. I'm wondering if we shouldn't support the bill as opposed to just watch it. I'm just curious.
Christy?
I think what you're asking is, will we have more political cachet, so to speak, if you took a position like support if amended or support, and then suggest the amendment? And I don't know, Laura has more experience in this area, but if you're not going to put your hat into the ring, sometimes your amendments are ignored. So I don't know what your perspective is on that.
Well, I would say what we're looking for is a fairly technical change, and it's going to benefit more than just CSLB. So if we suggest it to the committee staff when they're analyzing the bill, I think it would be accepted as a reasonable amendment. But certainly the board could weigh in and support it. We haven't really discussed the policy of whether or not we want to support the category, but we certainly could support the bill and then discuss it later on if the bill is chaptered into law on whether or not the board wants to move forward.
Well, maybe it's time to discuss the category first, and in short. But you had something to say? Christy.
Yeah, Christy.
Our registrar, Cindy Christensen.
I get that a lot. Anyway, it's like you were just saying, you haven't discussed the retired status, but if it is something that you'd like to discuss at this point, just as a concept, and then you want to move, just supporting the bill doesn't mean, in fact, that the board's going to promulgate this type of retired status in the future, but if you do go on record as support, it's totally up to this committee.
Nancy Springer.
I'm just curious, do we know if we've had many requests for the retired status versus in?
We have not had a lot of requests for retired because we haven't offered that category. We do have a pretty substantial number, and don't ask me to think of it off the top of my head, of inactive. Different thing. But there are a number of licensees that they're never going to work again, but having that license it means something to them. So I imagine if we do decide to implement this, we will get a number of people that, they just want to keep their license. They're not going to work again. They're going to be retired, but it's kind of a status thing for them. I mean, they worked hard to get it. They worked hard all their life.
My understanding was that it wouldn't prevent them from coming out of retirement. Laura?
That's correct, yeah, and that's the latest amendments to the bill kind of specify the detail that a retired licensee would need to comply with in order to reactivate their license.
Are you saying that those amendments are just in the event that that person would reactivate? Yeah. Is that what we're saying here?
Right. Those were part of the most recent amendments to the bill. Yeah, were to specify the criteria a retired licensee would need to meet.
We don't want to lose jurisdiction over even a retired individual.
Well, right. And it provides that if they're going to reactivate their license, they would need to comply. They would need to be fingerprinted if they weren't previously. They would need to complete continuing education if that was a requirement of licensure.
And how would it differ from inactive?
I think it's mostly in the term.
But how do you, yeah.
Is eligible for reinstatement or renewal to active status at any time, as long as they continue to pay the renewal fee for an inactive license, which is roughly half of what it is for active license. And I guess that might be one of the questions that we'd want to resolve is when they go retired, is there any kind of fee for that? Typically, well, right now, if you just let your license expire, you only have 5 years to reinstate it. So I think, those are the kind of questions that would have to be resolved. Can I go retired and then 10 or 15 years from now want to reinstate or reactivate, whether or not they would be able to do that? I don't know that the language is real clear on exactly how we would do this, but I would think the board would have some discretion to implement regulations that would define all of that.
Yeah, it does say that. Do they have to take, if they're inactive for, say, 10 years, do they have to take and pass an exam?
Nope. If you stay inactive, if you continue to renew inactive, you can reactivate at any time.
However, if you let your license lapse for 3 years or more, then you do have to take and pass an exam.
Well, it's 5 years, but
5
yes, 5 years. If you let it lapse, then when you want to reinstate it or get a new license, you have to take the exam again. You don't have to show experience, though.
So here's something I would like to suggest to the committee that maybe we might want to suggest to the board is that in our board packet, what if we had something in the way of a description in spreadsheet form that shows the differences between active, inactive, and retired, and the requirements listed across the top, or however you want to do it. I think it would really help us.
I think that would be a really good idea, and I'll work with Laura, and we'll put something together for the board so you can see the different categories and what it requires and what happens when.
Okay, Linda Clifford?
I like the idea of having the option. I haven't been licensed for 25 years myself. I'm not sure I'm really willing to just walk away from all that. So I'd like to make a motion that we, first of all, accept the amendment, because I think the amendment is critical, and that we support it based on getting the amendment, because the amendment is very important. And I think Laura's right. I think everybody benefits from it. And then the board can later on go into the weeds and develop what this retired license would look like, and maybe take, input from the industry on, what they would like a retired license to look like, so that it does have some value, because no matter what it is, there's going to be a fee associated with it. We can't we can't process it or manage it without some money to do that, some resources to do that. So my motion is that we accept the amendment and that we support the bill itself.
Is there a second?
Second.
Okay, let's have any other discussion. First, Christy?
The accountancy board implemented a retired status a couple years ago, and the language that I gave you was a sample from what their statute includes. So there's already a non-healing arts board that does it, and their experience was the same as yours, that they had a lot of interest from their industry in actually having a statement that they were a CPA retired or a contractor retired. So it's the same idea that they're able to do that. The thing they do, though, is they don't charge a fee for retired status. They charge a fee for the application when it's filed, but then there's no fee collected after that. But like you were saying, that could be done by regulation. So one thing you could do is include a copy of their regulations so you can see how a program could implement it. You don't have to do it that way, but so that the board members get an idea, because the way the statute would be written, as is included in the bill, is pretty broadly worded so that you have more discretion in how you want to implement your program. But you could have a copy of the regs just so you can see how a program implemented a retired status.
Comments? Augie? Beltran?
We would suggest to the author's office that they include this language in the bill.
This is our amendment, that's not his. Okay.
Right. Right, so the bill has been amended since it was introduced, but this is an additional amendment.
Okay.
Anyone else want to comment on the committee? How about members of the public? All right. All right, so it's been moved and seconded that we not only approve these suggested amendments, but also approve the bill in theory. All those in favor?
Yeah.
I'm sorry, we'll take a roll call.
Joan Hancock?
Here?
Aye. Augie Beltran? Aye. Linda Clifford?
Aye.
Paul Schifino?
Aye.
Nancy Springer?
Aye. All right, AB 1060, Assemblyperson Bonilla. Is that next?
Yes.
All right. Is that one of the ones that was not in the packet?
This
Or
one's
just-
next.
Yeah. All right. 1060. Okay. The existing law requires all boards within the Department of Consumer Affairs to send a copy of the criteria for rehabilitation, as well as a copy of the statute that authorizes application for reinstatement to an individual whose license has been suspended or revoked. This bill specifies that This requirement shall be satisfied through first-class mail and electronic means if the board has an email address on file for the ex-licensee. Notes, let's see, this is my note. Contractors Board, we send by certified and first-class mail as we do not have email addresses for each licensee. So staff's recommending a watch position. Yeah, Laura.
This was presented at the March meeting as well, and the board just continued to watch the bill. It was amended slightly since then. It's still not a very substantive bill, although it moved out of the Assembly Policy Committee. So I could expect that it may still be amended if it continues to proceed further to have more substantive language if it makes it to the Senate.
Linda Clifford.
Linda Clifford. So we're already doing this, and the only change for us, unless it's amended more, is that if we have an email address, we have to send it by email also, if we have the address. We don't have to find the address.
Right.
We could be doing the same thing we're always doing. That'd be the only change.
Right.
Today. Okay.
Committee? Any members of the public comments?
Actually, Joan, if I could.
Yeah,
Paul
Paul
Schifino.
Schifino.
It says first-class mail and electronic means. If I wanted to argue the point, could I argue that I didn't receive the electronic means? What it should say is first class is required, electronic means is a courtesy, but by saying they're both required, how do you have proof of receipt? Is it the sending that makes it applicable, the receiving? It's like, it's a complicated legal provision.
It's only legal if the board has an email address on file at the time.
So what if they have it on file and they send it and the guy doesn't receive it? Is it valid? It just doesn't. It's you know, the first class is good because it's return receipt requested. You have proof you sent it, you have proof you received it. With electronic, you won't unless you get a bounce back or something like that. I'm just saying. I'm just throwing it out there as a. It's not. I don't like it, but watch whatever. It's fine.
Okay. I can discuss that further with the author's office, and if the bill continues to move, we can try to address that issue, and then if it is going along, I'll bring it back to the board for more discussion.
Any further discussion? Members of the public? Turn your microphone off. Okay. All right. So we're going to watch that one. Let's move to the next two are listed on the agenda. What?
Can we watch it with with Laura going and saying something to the author about what Paul said?
I think that's what we indicated.
Okay, good.
Okay. So the next two, they're listed in the agenda item C section, but they're not in the packet because we're on AB 1208, Assemblyperson Frazier. We're not going to proceed with this bill, or?
Right. The
Something
bill,
changed?
as in print now, does have maybe an indirect impact on our licensees, but it's not moving at this time, and the author's office has indicated they don't plan to move forward with this language. It will be amended to address a different subject. So I had it on the agenda in case that was not the case when the committee met, but that was what the author's office indicated. So, and that would be the same for AB 1386. Yes, when that was noticed, the bill did impact the board, but it no longer does so. It's been amended to address a different subject.
So spot bills.
AB 1208 is, I would say, a spot bill, and AB 1386 is now a different subject matter.
Since we're on the subject, for the benefit of committee members and public that don't understand what a spot bill is, would you explain that?
Sure. Bills need to be introduced by the end of February in the legislature. A lot of the times the ideas aren't fully developed, so an author will introduce what's called the spot bill, which makes either a minor or technical change to the law. It might state just intent language, or it might make a minor change to the law that they put in print just to have something that they could put in print and it has some substance, so the bill could get referred to committee, but they don't intend to pursue the idea.
Any questions? Comments? Committee? Public? All right, let's move to SB 119, Senator Hill. Okay, this is involved. And other things, this bill would require the board to adopt a program to enforce violations of provisions relating to excavation. This bill would authorize the board to require a contractor to undergo a CSLB-created training, levy fines for violation of proposed excavation laws, and other sanctions, including suspension of a contractor's license for a violation. Staff is recommending we maintain a watch position on this bill. So we had a lot of discussion at our March 16th board meeting about this, and before wading into another discussion, if Dave Fote, there you are, is still here, I was going to ask you to, it's these glasses, describe CSLB's participation at the stakeholder meeting that Senator Hill conducted. And I understand you were there and you've been very involved in this issue. So would you give us some background?
Yes, just to clarify, I didn't personally attend. Our supervisor over Intake Mediation Center, Cynthia Moore, has been actively involved with the stakeholder at the stakeholder meeting, but also with Senator Hill and other industry partners. And it's been very effective for us to attend these meetings because what we've been able to do is to establish an enforcement protocol that makes sense. For the most part, working very closely with PG&E and other public utilities to educate contractors when they do offend. If they pay restitution for the injury, for the damage that occurred, a warning letter is issued and they're scheduled for training. Those contractors that continue to reoffend or are not receptive to changing their business practice are issued a citation. So I just, in summary, we're pleased that we've been able to play a part in developing how this will be implemented, how it will protect the public.
Laura.
So at the March meeting, we had some discussion about this bill, and I originally recommended the board support it with the suggested amendments, and the board didn't want to take that position. So they haven't adopted our suggested amendments. And in the stakeholder meetings, which I've been participating in, and Cynthia has as well, the bill currently creates a new entity called the California Underground Facilities Safe Excavation Authority. It has members appointed by the governor and the legislature. It's not very well defined in the bill, but it appears that maybe this authority is meant to actually hear all of the violations of the law when there are complaints and make judgments. The author's office has indicated they don't expect to be able to create the authority the way the bill currently is drafted, and they're considering creating something new at CSLB to handle some of this responsibility. And that's all the information I have at this point.
With corresponding funding?
I think all of that we need to work on. They don't have a funding source in the bill now for the authority except for fine revenue, which is not a reliable source of funding. There are different structures they're going to look at. I told them I would do some research as well and get back to them. It's still very much a work in progress, this bill.
And that new adjunct of our board would be an educational?
Well, it's not clear.
Educational driven?
If it's meant to actually be an entity that hears all of the cases when there are violations of the excavation requirements, or if it's, we talked about just referring it out to the appropriate disciplinary authority. PUC would have authority in some instances, state fire marshal, some are CSLB. It's definitely not well defined at this point.
Well, I had a few questions. Some of our response had to do with the cost of our having to develop some sort of training program, and what type of training program would have been anticipated. It seems like we're already responding, saying we can't do this, but I want to know, what are we responding to?
The way the bill is drafted, it does require the board to develop or to refer violators for a training program for first-time offenses, and it's not clear whether or not CSLB provides the training. There are third-party trainings available now. If we could simply refer someone to one of those to complete, and CSLB didn't need to develop the training, that would make it easier.
But we're talking about costs of $116,000 initial cost and $90,000 each year. I don't know where those numbers.
That would be if we needed to develop the training ourselves and provide it.
And that's what I'm asking. What would that be based on?
We would look at doing some type of online training.
Online interactive type of
Yeah.
thing, and we would ask our Chief of Public Affairs, Rick Loeb, to add that to your list of to-dos. Is that I mean, we do some sort of notification for people already. We have the Dig Alert notification on our website. Do we also have, and we had an actual campaign years ago that we started.
We do. We've done different types of public awareness. We've done industry bulletins on this. It's included probably in the exam for all of the impacted classifications, which I think is over half that need to be aware of this.
Is there a possibility of doing some sort of exam? I think years ago I took something that had to do with asbestos. It was
asbestos certification?
Yeah, it had to, and you filled it out. You had to take a test, and you filled it out, and you sent it back, or maybe it was online. I don't remember, but it was several years ago. I mean, is it possible to just do something like that? It was interactive in the way that it was a written response, as I recall.
If this requirement to go forward, were to go forward, we could certainly look at that. I think at this point, with so much of the bill undefined, and this is now a relatively small, minor part, and if they're looking at adding additional responsibility to CSLB, we have
So
larger
I guess what
issues.
I'm talking about is outside of the education and training that is being requested by the bill or foisted by the bill. Is there something that we could do in a collaborative effort to, ensure to our public, to the people that we designed to protect, that we're doing everything we can do?
Yeah, I definitely think that's something the board could consider, and maybe we can discuss and either put on another board agenda, or we could have the staff discuss it, because we get about 100 reports last year of violations of this, and we know there are far more out there that we're not hearing about. So we could look at different ways to try to get more information out there.
I mean, I'm particularly interested in this issue, and we talked about the issue a few years ago with relation to PG&E, as I recall. We have a partnering program with PG&E right now, still?
Yes, we're part of PG&E's Gold Shovel program, and they have a training program that I'm not aware that we just simply refer over to them, and they provide the training, and that's been effective, and that could serve as a model for other utilities or other situations.
Just another curiosity I had is with these strikes, and we've had some recently in Fresno, major but not like San Bruno, do we have any idea of how many of these strikes? I mean, one of the issues that I read here is that we have no jurisdiction over individuals that are not licensed. So one of the questions that I have is how many of these strikes are related to, do we have a breakdown of anything? I mean, it doesn't come to us firsthand. I get that. I realize that it's under someone else's.
Well, what I've been told by PG&E is that before we started the partnership with them, they were being hit 7 times a day, and it's significantly been reduced, and that for the licensed contractors that are hitting a line, they're not reoffending, and so it's having a real impact. That's not to say that somebody digging in their yard or a farmer or somebody else won't cause damage. It does happen, and we can provide you those statistics. It's just the feedback we've gotten from PG&E as the program we put in place has been very effective.
Good. It would be great to get a breakdown of those statistics and others, not just, individuals and registered or licensed contractors, but licensed engineers, Caltrans workers, et cetera. Linda, did you have a question?
I have a couple of questions. I mean, first of all, it's just hard for me to believe that we can develop a program and then track it for these costs. I mean, I know what we've looked at in terms of creating fingerprinting, going back forward. So, I mean, if we have to have if we get in and we're doing this training and then we have to track who actually takes it, because it's no point in doing it if we're not going to know whether it's actually, I mean, part of the disciplinary process is you have to take this training, right? So there would have to be a record of you taking it, and we'd have to maintain those records. So these costs just seem completely unrealistic to me. I think Laura's right. The bill, you can see all the revisions that have happened, but currently they're revising the existing definition of excavation to include penetration of the air.
I saw that.
I mean,
yeah.
you have to ask yourself, you know, what is this?
I think that what they're
is-
talking about there, from my understanding, is moving dirt from one pile to another. I mean, you know, and in that instance, go ahead. Maybe I have it all wrong.
So what I'm saying is, I think that there's so much left to do here. You know, it's a mighty thin pancake that doesn't have two sides. So there's a lot of contractors out there who, you know, have made phone calls and have not been responded to. PG&E also has issues with older lines that have nothing to do with contractors. Certainly the San Bruno situation was that. So, you know, I think we got to have a clear idea of what is the goal of what's going on here. Because if it's just to be one-sided in looking at this and not to require responsibility across the board. And if the contractor's licensed, the best thing I think you said in the last few minutes was, what do we do with the unlicensed contractors? You know, how does this equitably work if we've got a bunch of unlicensed contractors out there who are doing this, and all of a sudden we can't train them, we can't get at them, we can't discipline them. You know, this bill needs to think about how it, you know, equitably addresses this issue so that it's not, you know, some poor licensed contractor who makes a mistake and then learns right away and fixes it, right, against some guy who may or not care.
So I think that's why we're asking for a watch position at this time. But, I mean, having said that, I would really like to see what we could come up with in the way of strengthening what we do already, I suppose, and you know, any way of communicating this to our contractors. And that being said, I mean, that is all based on the assumption that our contractors offend a lot. And you're saying, I think what I heard you say with those 7 strikes a day, they were not contractors, and you followed by saying that the contractors that committed those strikes or did those strikes haven't had a second strike.
Just to clarify, PG&E reached out to us and stated that they were being hit 7 times a day, and it was far too much. And so,
Were those
working with them,
licensed?
well, it's a combination. They were just being hit. But the way they brought it to us, the majority of the hits were by contractors, whether licensed or unlicensed. I would suggest, in response to Member Clifford's comments, that we could use information relating to unlicensed contractors that hit a line for our sting targeting, for our proactive targeting. So that's something we can talk to the utilities about.
Okay, anybody else want to wade into this discussion? How about members of the public? All right.
Joan,
so-
can I ask?
Yeah, Linda.
There's some suggested amendments here. Laura, are you asking us to weigh in on these, or just, are you telling them about us? Are you telling them to us, or what's the concept here for these suggested amendments? Are they ours, or?
These were staff suggested amendments that the board adopted at the March meeting to suggest. So I have provided them to the author's office. So they are aware of the amendments, I think, because they have larger issues to deal with, and they have not been adopted because they need to rework the whole enforcement model of the bill.
I don't think support one means support all either.
No, I understand. It's watch, right?
Yeah.
It's watch because we don't know what's going to happen at this point.
Okay. All right, thank you. And thanks for indulging me. Moving to SB 465, Senator Hill, that's also in a handout you received today. Okay, we're going to be looking for a motion to approve SB 465, and that would do 3 things. 1, it extends the sunset date for the Contractor State License Board and authorizes the appointment of a registrar from January 1, 2016 to January 1, 2020. 2, it eliminates the existing requirement that applicants demonstrate evidence of financial solvency by possessing operating capital of $2,500. And 3, it increases the amount of the contractor's bond licensees are required to maintain from $12,500 to $15,000.
So moved. I did.
All right, is there any discussion, committee members, members of the public? Good, all those in favor? A roll call?
Joan Hancock,
Aye.
Augie Beltran, Linda Clifford, Paul Schifino, Nancy Springer.
Next, we have SB 560, Senator Monning. At the March 16th board meeting, the board amended this version, or amended the version of SB 560 that we approved in December at that board meeting. That allowed DCA Council the opportunity to refine the previously approved language, and I think we're good. We don't need a motion, as we already approved it. All right, so SB 561, also Senator Monning. Again, at the March meeting, the board approved language to allow acceptance of electronic signatures. These amendments will be added to the bill later in the legislative process. The California Solar Energy Industry Association asked for 2 additional changes, and staff, you are working with legal counsel and the association regarding this language?
Yes, I think we have agreement on the language. It's not yet in print, but I would say the changes are fairly minor, but they're intended to make the industry comfortable that a home improvement salesperson can register prior to being employed with a contractor, but also make it clear that they can't work as a home improvement salesperson until they're affiliated with the contractor.
Any discussion? Public? We're good. Agenda item D. This is the review and discussion regarding the legislative proposal to authorize sharing of licensee information with the Employment Development Department, and Chief of Legislation, Laura Zuniga, is going to wade into this with an update.
I actually don't have much of an update on this proposal. This is language the board had approved at the March meeting, and we thought about trying to seek legislation this year. After that board meeting, I think we heard from the Department of Consumer Affairs that they were also looking at this issue because it could impact more than just CSLB, and they were going to look at a potential department-wide solution. So we did not pursue language this year. If there is no department-wide solution this year, well, then we can bring it up for a legislative proposal for next year.
So it's premature. Okay. We won't see this on our packet as well?
Right.
Okay, agenda item E. I think you're going to present this one too. Review and discussion and possible action regarding the 2015-16 Legislative Strategic Plan. We're on page 79 of your board committee packet.
So since the board's not having its regular strategic planning meeting, I think we talked at the March board meeting about updating the objectives for each division, and so these are the legislative objectives for this coming year. I think they were all sent back to the different committees. I think we had a brief discussion at the March board meeting. But this is what we have for legislation, I think mostly developed at the staff level. So this is the committee's chance to review the objectives and see if you have any input, want to add anything, make any changes.
Paul, did you, I'm sorry, I thought you raised your hand. No.
I can.
All right. And your pen.
Go through each one of these one by one, and then we're going to chat about it.
Sure.
That sounds fine. Let's do it that way. That way I'll keep my mouth shut.
The first objective is to seek legislation to authorize sharing of licensee information with the Employment Development Department. We just discussed that as our last agenda item, so I would say we'll probably revise the target date to the end of this year or early next year.
So do you want December 2015, or do you want
Probably want to go to July if you're going to do.
Let's do July 2016, and that, we'll work on it before then. But so the second one is to prepare a legislative proposal to eliminate the capital requirement for licensure and increase the contractor's bond by corresponding amount. We're ahead of schedule because, yes, it was included in SB 465. The third one is to prepare a draft proposal a rewrite of the contractor state license law to make the law easier to follow. This is in process. I have a draft that I'm working on. It's a long process, but I certainly have a draft available by the target date.
Good summer reading.
Yeah.
Paul?
I think when we got into this item, what we were trying to address on a global level was a law that is difficult for contractors to follow and likewise for the court system to implement. That's the overreaching objective, right? And so therefore, if you ever end up in a court situation, the litigants all know where the law stands, the judges know where the law stands, everybody understands what's happening. And right now it's cacophony of crap, perfectly honest. That's a legal term, by the way.
We edit those things out.
Of course.
Yeah, we edit those. Rick, you got to get that for me. And one of the big things that we were trying to address at this point was the 7031. That was where I thought the overriding confusion came from, or battling came from, was the 731 disgorgement provisions. And that's not in here specifically anywhere. Is that where we're trying to pick up on that, or?
So this objective is, when we talked about this, I think maybe at our April committee meeting last year, we talked about sort of two tiers to this. One, simply that the way the law is written, it's very unorganized, and it's not easy for someone to follow and understand where the requirements are. So it's hard for licensees to follow, for staff, myself to follow. So that's, I guess, one objective is just to simply reorganize the law without making significant changes, substantive changes, but simply do a reorganization. The second component is a rewrite of the problematic provisions, and so we were going to break them down into different issues. And so that's the next one is the home improvement provisions as the first one to work on. 7031, I think the intent was to work with different partners in industry on developing a proposal that they would bring forward.
Yeah, I'll just add a little bit on to that. When, we heard the legislature loud and clear that that's not really a mission of Contractors Board because we're here to protect the consumer. However, we think that there may be a medium road where maybe the language would just direct it towards contractor v. contractor and maybe include something with public works in there, because that's where, although it never really comes before us in an actual case, it seems like it's settled out, so we never really get to see what happens. It seems those are the biggest instances that we understand that are affecting the contractor and, the disgorgement issue. So that's what we'd like to work with, like Laura said, the industry partners.
So do we have other issues to talk about before we jump into these possible objectives, one of which would be 7031? Are we pretty
You
much
could add
done?
that as a specific, work with industry partners,
So
7031.
do we want to visit it now, or do we want to just,
Well, do you want to just add it right now?
I think we're talking about a formal discussion here. We're not just going to add it. But so if you're ready to have a formal discussion, we can just move forward.
Linda Clifford. So this is my second or going into my third year being on legislative, and Laura's exactly right. There were two fun logistics, right? So logistics was the first thing. Let's just get the thing where you can actually find what you're looking for, because right now that's just almost impossible. So get it organized logistically, then go and identify those areas. 7031 is absolutely at the top of that list, and is, obviously we should talk about that. But I mean, I think the logistics, putting this thing logistically through, is going to identify some other areas that really need attention in terms of either they're conflicting because they're over here and they're over there.
Sure.
Or, oh my goodness, I didn't realize, really said that because we haven't been paying attention to that thing, you know what I mean? So I think we want to approve 3 as, go get that logistics thing. And anything we know about now, let's add it on. But I think other things are going to come out of that, Paul. I really do.
So good, we're taking these one by one. So number 3, are we just going to do, let's do just a straight yes or no vote for column 4. You done? Did we allow you to finish your? Yeah. Okay, all right. So are we in agreement to approve number 3? Any other, is this a formal vote we're taking?
Approving or recommending approval for the entire.
Number three right now.
You might want to do the whole thing collectively unless you have problems with any of these areas that you think should be
All right.
modified.
I think we could do that. Do you want to, have we digressed far enough, or do you want to,
Well, I
we
can
have
just-
the arbitration program to
Right, so we
identify?
briefly talked about doing, so we'll look at a rewrite of the home improvement contractor provisions, which we've discussed previously, and then also amendments to the arbitration program for issues we've identified at previous board meetings as well. And we were unsuccessful in our prior attempt at legislation.
Where did we leave off with our arbitration legislation at the last meeting? I don't think we took I think we moved that vote on. We did not vote on it.
We sponsored legislation in 2013 that would have made this change to the arbitration program and a couple other changes. The bill was amended in Assembly Judiciary Committee to make unrelated changes that the committee wanted to make to the arbitration program. The bill got out of committee, and then the company that we contract with to run our arbitration program, AMCC, said they couldn't comply with the requirements that would now be imposed on them. And so we were at an impasse with the legislature as to how to resolve it, as they didn't want to go forward without the additional changes. So we dropped the legislation, and so we've never been able to get the change that we've been seeking.
And we also raised it as an issue in our sunset report.
Okay, we need to keep, forging ahead. All right, so we are going to affect 3, 4, and 5. Well, all of them really.
1 through 5.
That's what do we need a formal motion?
I think the request is to approve it, and then I don't know if you wanted to add the additional objective that Mr. Schifino.
Yeah, let's talk about that now. Can we do that? And then we'll ask for a formal. Augie?
Chair, I make a motion.
Anybody want to second that? Or?
Do you mean the first 5 items? Put those 5 items to bed, then we'll go with the possibles and more chit chat. Understood. Second.
I'll second that. Or,
Thirded.
go ahead.
Anybody else? Any members of the public want to respond? All right, roll call.
Joan Hancock?
Aye.
Augie Beltran? Linda Clifford? Aye. Paul Schifino?
Aye.
Nancy Springer?
Woo-hoo. All right, other possible objectives. Now,
I'll
Linda
go
Clifford.
first. Yeah, right. 7031 continues to be a real thorn. It's so inequitable, and it doesn't seem to have any benefit whatsoever for the consumer either, because the consumer doesn't know how to use it, or it's actually not something that can benefit them. So it's very inequitable. It's primarily used, it feels like, at either the bidding process or the payment process to not end up paying. And there's a lot of people who might fall into the category of not having something done in a day. And we're all involved in that process. In other words, it's, it's checking a workman's comp certificate on renewal, or it's changing out a qualifier or something of that nature that is being processed here, right? And while I think we're incredibly, being the chair of licensing, I think we're incredibly efficient. But having said that, time does pass. And so.
let me just interrupt you.
Okay, sure, go ahead.
Because I'm going to interrupt you for a second. For the benefit of those who don't know, I'm just going to read a short this is from the Business and Profession Code, Section 7031, provides consumer protection as possible. Under subdivision A, in order to file suit for compensation, a contractor must prove that he or she was a duly licensed contractor at all times during the performance of that act or contract for which the compensation is sought. And under subdivision B, any person who hires an unlicensed contractor can bring an action in court of competent jurisdiction for the recovery of all compensation paid to the unlicensed contractor for performance of any act or contract. And the conversations that we've had in the past is what happens in the merger of subsection A or B, because A is requiring that the contractor be licensed at all times, and B is saying if you're not licensed, you are subject to disgorgement of all profit and all compensation paid to an unlicensed contractor. So the concerns that a lot of us have had in the past have to do with the unfairness in a situation where someone becomes unlicensed due to suspension. It could be from as a result of many things.
A judgment that wasn't paid, but you have an appeal and.
You sure? Would you mind using it? Go ahead.
Yeah, you could have a judgment, you could have an overlapping of, like I said, replacing a qualifier, and the fingerprints hadn't come back from DOJ yet. You could have a situation where your workman's comp was being renewed and your renewal carrier sends in your workman's comp certificate, but they miss it. It comes in at 5 o'clock that night instead of 8 o'clock the next morning, technically speaking, right? You don't have workman's comp for 24 hours. I mean, a person could have a multi-million-dollar contract, not be licensed for a day, and if a public agency or someone else decided to take advantage of that situation, could end up doing millions of dollars of work with no payment.
So we had many concerns with 7031, some of which had to do with suspicious folks that are trolling for contractors that are in this kind of quasi-state between subsection A and B, through their no fault of their own, or maybe through their own fault, but inadvertent fault. And so really I think where we got in some of our discussions was really focusing on, and I think you touched on it, Cindy, the contractor relationship. So clearly this is an issue that we're all concerned about. Go ahead, Paul.
So we're condensing it down to, we have a problem with 731, the disgorgement, the inequity, technical violations that can result in these egregious situations where companies go bankrupt, and that absolutely happens all the time. And I could give examples, I know of them, and it's a catastrophe. Businesses go out of, close down, mom and pops because of this stuff. So we've addressed this before, and it stalls, and it stops, and somehow we just don't get anywhere. What are we going to do this time? What can we do this time that makes it different than the last time we tried to get something done? What concrete hurdles can we give ourselves to our staff that we can request? And I'll give you an example of one thing is if there's any industry meetings or any stakeholders meetings or anything like that, I want to know about it. I want to be there. I want to be part of the process. I don't want to just come to a committee meeting and get a report that says we did all this and it didn't work. I want to be part of the we did all this. Personally,
I would like to suggest that we have an official stakeholders meeting here. We had them when I first came on the board, and I'm wondering if we could arrange such a thing.
We can most certainly arrange a stakeholders meeting. I just feel that it's probably more appropriate that industry would carry such type of a bill instead of the board, but I most definitely think we should be involved to provide our input. But in terms of, we kind of have to walk a fine line too, because the whole board has really not taken a position on this. Well, I think the last position was they didn't want to do anything. There was no movement on it. So you have to really walk a fine line. Does the board want to take a position on this, number one, which, you want to move forward on it or whatever, work on it? But if they don't, it's like if you are participating in these stakeholder meetings, wherever they are, you have to represent yourself as a board member and not the board, because there's the board position, and then Paul SCHIFINO, Linda Clifford, Joan Hancock as contractors representing themselves in this issue. So it's kind of a twofold thing. But, I mean, if just my opinion and working with legislation on this, when we went and talked to Senate Judiciary, and that's where this bill would go through, they feel that consumer protection is just our main mission, and the perception of a board moving forward with this type of thing where the consumer could be harmed. Well, basically they said, you're supposed to be licensed. You are required to be licensed every single day. They know about all of our hurdles and everything, but they feel from a consumer protection issue, if somebody's not licensed, they should be entitled to all of that money. That's just the way the Senate Judiciary is from the board perspective. However, if industry can make an argument, say contractor v. contractor.
I don't think that that's the full board's perspective, and I think that's what we're trying to say today.
Well,
we
and
don't
that's,
believe
but I
that
guess
that's-
I'm just saying, but I mean, that's my recollection that last time there was no, it didn't get out of the board one way or the other as to whether or not they wanted to move with
I think
7031.
the
Am I
last
correct, Laura?
thing we did was we actually made a huge attempt to get it on issue for sunset review, and the board thought it was important enough to have it reviewed.
As I recall, so we sponsored the legislation a few years ago. It was unsuccessful for the reasons that Cindy stated. We did bring it up in the discussion, I believe, of the Sunset Review Report, and so I want to say it was maybe at the fall or the December board meeting. And there was, and I believe Steve Sand's recommendation was that when the board not pursue legislation on this issue, again, for the reasons that we've previously discussed, and that we participate in, if industry is going to go forward with the proposal, that we could certainly be involved in the discussions and work with them to provide assistance. But there was, the board, I don't believe, has recently voted to pursue anything in this area.
So in 2013, Senator Monning pursued SB 263, and that was essentially what we're talking about here today, allowing a court to determine when a contractor had substantially complied with the licensing requirement. It does seem to me that there are enough of us here that are suggesting that we do think it's important, and we're willing to limit it to a certain set of circumstances. Linda?
Yeah, I think, Joan, you're on the right track. I do think that there is concern across the board, and although we have tried not just that time but other time, there's been at least 2 times that I can recall that we've tried to go ahead. In some cases, we just haven't even gotten, out of the starting gate. In this case, we got farther. I think Cindy's right. We're gonna run up against the same issues, but I also think that because we are so concerned about this and because it is so upside down, that at the very least we should consider, suggesting, if we get a positive vote, that the board does hold these stakeholder meetings. We did at least light on it in the Sunset Report, even though we didn't say we were going to do anything legislatively. And I do think the board is, tired of not being able to push it forward. That's a frustrating situation for the board to be in. So the concept that the industry could move this forward and we could participate as much as possible legally and to support that seems like something we should push forward to the board. I mean, I really think it's important that it does end up at a board discussion.
I also would like to say that the response that we get continually is that pursuing this change and amendments to 7031 were removed. I understand the Senate Judiciary Committee, they took a look at this. I've never seen their response, and I would like to see that response, and perhaps you guys could provide that to us. They were concerned that any change would be viewed as weakening the consumer protection provided by BC BPC 7031. So, I mean, we're all concerned about that. And we're also concerned about the ill effects that the current law is having in certain situations that are unfair and seem to be, in many cases, very arbitrary when we're talking about someone who may have had their license suspended for a day. I mean, I have a hard time understanding, and I guess that's why I would like to have some sort of response from where we're getting our responses. Yeah. All right, Laura.
If I can just add, what Cindy was speaking about when we met with Senate Judiciary Committee staff, they didn't provide us anything in writing, but their viewpoint was very clear.
When was that?
That was in 2013, so I want to say maybe April or March. The bill made it out of the Senate B&P committee with that language in there. So from that committee's perspective, they were fine with the change. Senate Judiciary Committee would not hear the bill with that language in it. We had a Democratic author up for the bill. They wouldn't hear it. They were very clear that they felt that they knew that 7031 is a significant hammer that is held over licensees, but they think it is so important for licensees to maintain their license at all time that this motivates them to do that. We talked about the issues that had been raised about problems with the law. They wanted more concrete examples, but they also didn't feel there was a need for a change. There have been several bills that have gone through the legislature to try to amend 7031 in different ways. None of them have been successful. So I don't think, just in my opinion, I don't think the circumstances have changed significantly since the board sponsored that bill. That would lead to making a difference if the board tried to sponsor additional legislation. I think there needs to be something different. It needs to either come from industry. There needs to be a different approach. There needs to be better documentation of the problem. But it's not an issue that directly impacts the board and what we do here, which is maybe why it would be more appropriate to be sponsored by the impacted parties.
Paul Schifino.
The law automatically regulates contractor-to-contractor relationships, and that's what we're having probably the biggest problem with. So for the legislature, and this is where I get incredibly frustrated, and my suggestion that I would like to know when and where these meetings are had is my ignorance of the political system, because I'd want to sit in that room with the Judiciary Committee and hear that. I would really want to address their concern, because I find it so offensive. But the point is, the legislation regulates us as contractors, because I am a contractor. That's why I'm on the board. It's okay for me to talk about being a contractor as a board member. So is there an opportunity for me to talk to this Judiciary Committee as part of that meeting and say, hey guys, this ain't right? Or is that something we're not allowed to do as board members? I don't know how that works.
All right, Augie Beltran.
Okay, so what we're looking at here.
Wait, before you start, I think Paul deserves an answer to that question.
Certainly, if we have another meeting, a stakeholder meeting, I think any board member could be there and express their own views, not representing the board, but they could represent their viewpoint as a licensee.
I was referring to the Judiciary Committee, not a stakeholders meeting.
Either way, I'm
way.
sorry, I got to interrupt here because
Wait,
we're
do
getting
we have,
into.
following that.
Through the
do we
chair.
have,
You guys, you're getting into a really dangerous position here. You guys are board members here. You're always board members. Doesn't matter if you're a stakeholders meeting, some judiciary meeting, or whatever else. I represent the public, but I'm a labor guy. But when I'm here, and wherever I go, I'm a board member. Now, staff has been very clear that somebody upstairs doesn't want to cooperate. So now we're beating this dead horse. Sounds to me like what the contractors need to do is get their associations involved. Because right now, you're spinning your wheels, and you keep going over the same road over and over and over again. You need to talk to your association. Staff is clear. I think everybody here understands that staff knows the rap, and it is what it is. So you need to talk to your associations if you're really passionate about this. As far as this goes, I think we're beating a dead horse and you're killing time.
Okay, thank you. Response? I mean, I think we're entitled to get some sort of access to whoever the representative of that committee would be. Maybe could we invite them to a stakeholder meeting? And what is the usual posture for such a thing?
You know, it's whatever, you know, the committee, the board directs us to do. If you would like us to hold a stakeholder committee, they probably would be one of the parties that would have input, and you could discuss it if they, you know.
What parties are you referring to?
The Senate Judiciary.
Okay,
staff.
I think that's what we need to
But, you know,
hear.
we could invite them to these little stakeholder meetings, but there again, if there are, you know, these stakeholder meetings may be turning into board meetings because of the, you know, 3 or more board members. So stakeholders could turn into a board meeting.
Well, we
That's
could use
just
the
fine.
same sort of rules of procedure, and I'm sure that we would be advised appropriately by our legal counsel to not get ourselves
Right.
involved in that. I think it would really be an act of just getting it straight from the horse's mouth.
Well, unfortunately, under the Open Meetings Act, there's no exception for that. So if the board wishes to approach the issue, they would have to vote on it in a noticed meeting and delegate it to someone. The minute they do that, then we're into noticed meeting land. So, you know, the board could appoint a 2-person advisory committee, but it would just be to get information gathered, not to take a position on anything. That would be exempt from the Open Meetings Act. But any other committee that was delegated a position, argument, that sort of thing, would have to be noticed, and the public would have to be invited to attend. So a workshop of some sort would be the best avenue to have all the members participate if they wanted to, but it would have to be noticed as a board meeting.
So maybe that would be a good way to go. Appreciate that and respect the fact that you're concerned about how we perform according to the Brown Act and Bagley-Keene. But I think
Bagley-Keene.
your idea of an advisory committee is well taken, and wondering if committee members would be interested in that, and if so, who? Are you raising your hand?
I'll volunteer.
Linda?
Yeah, sure.
Okay.
Maybe we can work with Cindy, because I know she's got some ideas about it.
So,
I think what you clarified for me is this is why one of the reasons we can't participate is because it makes it a quorum and a noticed meeting. So that helped me understand why, as a stakeholders meeting, we're really not participating members. So that clarified a lot, and thank you, Christy. So if we just do it as a committee, what would that look like, though? Just so we have Linda and I work with Cindy and Laura to come up with some type of a stakeholders meeting that's held. All the board members can't show up because that creates all kinds of problems. We call it a workshop, and Linda and I show up, and we're okay?
Well, if you're,
What does it look like?
if, it just depends on what the purpose is and what the board's delegating. And it would have to go to the board to have the workshop. They would have to authorize it. So it would have to be before the board. And if it's just for you to meet with various people and talk to them one-on-one, I don't think it'd be a problem. But if you're going to have a full-on workshop, I would recommend that be noticed. Because you're asking for people to give input, a large group. I think that people would argue that it might be some form of a meeting. So, but if you were just talking about 2 people meeting one-on-one with the legislator, that would be different, or their staff. That would not have to be noticed.
So as far as, getting us back on task in terms of this strategic plan here, would your objective be to appoint a 2-board-member
Advisory
committee to work with stakeholders on clarifying issues with Section 7031?
Well, not just stakeholders, I don't think, but approaching judiciary staff is what we're talking about.
With stakeholders and members of the legislature? Is that what you're talking about? Meeting with staff of the legislature?
I think that's what we're talking about,
Okay.
yeah. Could that be noted for the record? As our objective?
Was that the motion, or?
you want to vote?
I think we're just putting that as an objective right now, and if it's ripe for a vote, we could do that as well. Any other discussion?
Does it?
I don't think you can comment. Sorry.
Does it make sense to have Paul and I meet with Cindy and come back either to the committee or, and say, here's what we're suggesting the committee / up to the board consider doing? As
I think
opposed
if
to
you're an
going off and
advisory
doing
group
something.
and our council is suggesting that it's okay for you to approach the Judiciary Committee, then you can do whatever you want under her advisement.
Well, what I'm talking about is it has to be approved by the board. So you would have, this
Right.
committee would have to recommend to the board that they appoint a two-person advisory committee to explore a legislative amendments to 7031 or hold a stakeholder group meeting, which I think should be noticed, and have everybody attend and have an open.
So are you
stakeholder
saying that every advisory committee appointed out of committee has to be approved by the full board?
No, but what I'm saying is because you're talking about legislation that impacts the board, that's the province of the board to decide what areas they're going to be exploring.
I don't think at this point we're to the point where we're trying to determine that. I think one of the things, this is a fact-finding mission
Okay.
about,
Can I
I
make a
think,
suggestion?
can I just finish? Some of the reasons
Mm-hmm.
that the information that the Judiciary Committee had
Okay.
and the reasons for their decision.
Sure.
That would be helpful to us.
Okay, I could see that, two-person advisory committee, just to information and fact gather and report back to the board, or to
Would-
the committee, sorry, to the legislative.
Would that be
But
amenable?
unfortunately, right now, the agenda item is legislative objectives.
Right.
So it would have to be couched in terms of an objective in terms of legislative.
In terms
objective.
of voting on it right now?
Yes.
Though we can vote on all of these other things?
Right.
So in my terms, it means we don't have an agenda item that we could actually vote on.
To do
other
what
than the
you're talking
objective.
about.
Right. All we can do is the objective,
Right.
and that's all we can
So,
do.
yeah, so we're just going to stick with the objective, which is to get the legal inquiry started.
Well,
Can I-
go ahead.
If I could just make a suggestion, these objectives are going to go to the full board at the next board meeting for all of the committees. In the interim, until that period, perhaps Paul and Linda could work with Cindy and myself to discuss this issue further, and then we could put an objective to the full board, and we would properly notice it at that time.
Okay.
I think that sounds great, as long as we can move forward with what we just heard was permitted in terms of gaining whatever information we would get from the Judiciary Committee.
Right, I think that the problem is that you didn't notice that issue for the agenda, and what you noticed was approval of legislative strategic plan objectives. So what you would have to move on at this meeting would be the objective that you're trying to reach in a time frame that you're expected to achieve that objective. 'Cause
Okay, I'm
that's-
just a little confused here, so I don't understand what this column at the bottom of the page is for then, where it's
That
would
allowing
be-
us to insert objectives.
That would be for a
with
new
the-
objective that you had, which would be the issue is 7031, but I think the suggestion that Laura made is that you and Paul work with us, we go talk to Senate Judiciary, that way it'll give us an opportunity to frame that objective with the target date, and then bring it to the full board. So instead of coming
Yeah.
up with it today,
Right.
or voting on it, we kind of work with you, frame it in a good way, and then bring it back to the full board.
You guys are good with that?
That
Okay.
that works for me.
All right. Any other discussion on this matter?
I have something to say.
Sure.
The smell test.
I,
think it's wise to take it to the full board, the contractor and somebody else. Because you are treading in dangerous waters.
Yeah, and I'm fine not being on,
No, I'm just saying, it just, could be another contractor. Does it have to be a contractor from this committee? I know Paul's kind of passionate about this.
Yeah, and I may be the one that shouldn't do it because I am so passionate about it, to be perfectly honest.
And
But
once again, that there's a value to go to the full board. Maybe we can
chair of the board appoint 2 people, which is the proper process anyways.
I'd be amenable to, Linda, you can work with Augie. I mean, we can do this now rather than put it off to another board meeting.
Because our next thing is a board meeting. Our next meeting is a full board meeting. We can ask staff to agendize this to the next full board meeting, and then the chair of the board can say, okay, you pick this.
I think this goes to the chair, but
But
I'd do it with you,
I would
Augie. We
like-
could do it now. But if you'd rather wait, then that's okay too.
We're not
You
going
can
to get
still
it through
go and
this
talk
time.
to them with staff.
Yeah.
I'm not saying don't talk to anybody, I'm just saying you gotta be careful when you got 2 board members that are contractors going to talk to somebody.
I'm in agreement. That's why I suggested I'm fine working with you or Linda work. I mean, we can mix it up. I think it's a great idea. Doesn't make any difference to me.
All right, why don't you go ahead and restate our position or your position, and we'll vote on it.
Well,
don't
all
know
we
that
have
we
is an
need to vote.
objective. All we have is an objective to vote on. In the meantime, right
That's-
now, what can happen
That's what I'm
is
suggesting.
we can chat with staff. I can talk to Cindy all day long, and I can talk to Laura all day long. I'm allowed to do that. And we can chat about what these goals and objectives might look like. So could Augie, so could Linda. We can have chats about what we're going to present to the board.
Actually,
that
you
clarifies
can't,
Why not?
because you have a serial meeting, then you have a serial meeting of the legislative committee going on.
Yeah, that'd be a problem.
Yeah.
I'm just suggesting.
Looking for an objective, I'm sorry, Laura, go ahead.
I was just suggesting at this time that the committee doesn't need to vote on anything, that staff would continue discussions with whatever committee members want to, that we're allowed to have the discussion, and we would notice something for the full board to review and properly notice it for the board meeting.
Perfect.
So we are not going to do an advisory committee meeting,
Not at this point.
No.
and you're good with that? And we're
I'm good.
going to leave it open with individual members talking with staff, and you can approach a judiciary committee on your own if you want to. Not in a representative way at all of the board.
Yeah, I wouldn't recommend that. You approach any committee without any kind of sanction or approval by the committee or the board.
No.
to do it.
I think all we ended up with, in deference to what Augie was suggesting when you're putting contractors all in the cup of soup, is that we're all Augie was saying, the same approach, the same stakeholders meeting that could involve the Judiciary Committee, everything we just talked about. All Augie was really suggesting is that before we get to the brass tacks with staff, that we mix it up a little bit with who the advisory members are. Am I stating that pretty fairly?
And taking it to the board.
And
next
have the
month,
board,
We've waited.
We wait,
God knows how long,
right,
it's another month.
right. And I'm okay with that. And the objective is, as Laura and both Cindy stated, the objective is that we're going to address 7031, we're going to have an advisory committee, blah, 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 blah. That all goes in the objective that we're approving right now. Is that fairly stated?
But we're not approving anything.
Okay. So we're not approving an objective at this time. We're leaving this open. So this has no function whatsoever. I just have one comment to make, and that is this. I think this board and all its members are very committed to the mission of the Contractors License Board to protect the public, and have been. And Paul and myself have been members of this board for almost 8 years. So I'm going to put that out there right now. And this is an issue that has been with us for a very long time for very good reasons, and we wouldn't be so passionate about it if we didn't think that in some way, shape, or form it is unfair in certain respects, and that's why it has taken so much of our time. And I want to thank you for members for indulging us this time. And
Madam Chair, don't we have to have a motion on that, though? Because aren't we adding this as an objective? Or did I miss that?
I'm going to defer to council at this moment.
I think we were just going to add it to the agenda so that the full board can discuss it as a whole as to whether or not they want to put an objective into the strategic plan and appoint a 2-member task force, which would be a public and, well, a non-contractor and a contractor.
So we're not being
So
asked.
this
at
committee is suggesting that this become an objective. And then we are going to move this suggestion to the full board.
But we're really not quite sure what the objective is at this point.
I think the committee's asking staff to continue to work on this issue and determine if there's an objective we could prepare to notice for the next board meeting. And at that time, the full board can have a discussion and determine if they want to proceed.
Okay, so it becomes an agenda item.
Yes.
Everybody happy? All right, we're not voting on anything today because we're going to move it to an agenda item. All right, any other legislative objectives that we will have to pass on?
Motion to adjourn.
So,
All right, it's been moved and seconded that we adjourn. Thank you very much.
We'll take a 5-minute break so we can get ready for